Hello and welcome to my channel. I'm Leanne Newton and we're going to recap this week's drama with the Lively and Wayfarer case, which includes 14 other parties. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I'm not a US attorney. Everything I say is my personal opinion as someone who understands and is able to interpret the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So, Jed Wallace notified the New York court that he has withdrawn his declaratory judgment claim against Blake Lively in Texas. Ryan Reynolds filed a motion for sanctions against Wayfarer. Sarah Nathan filed a motion to quash Leslie Sloan's subpoena. Child USA files an amicus brief in support of Blake Lively. And then 14 more organisations joined forces to file yet another amicus brief in support of Blake Lively. Jones Works' request to prohibit Wayfarer from enforcing their subpoena to Edgeworth was granted. James Patuska signs a declaration. Jed Wallace files a motion for stay of discovery in New York. Sloan and Sarah Nathan have their requests for extensions granted. Jed Wallace filed his opposition to Lively's motion to dismiss in the Texas case. And then Lively and Reynolds filed a motion to compel Wayfarer to give up details of content creators they've communicated with. So first up we have Jed Wallace withdrew his declaratory judgment claim against Blake Lively. This is in the Texas case, and this is just Wallace notifying the New York court that when he amended his complaint against Lively a few weeks back in Texas, he at the same time withdrew his declaratory judgment cause of action against her, which left one claim of defamation. So Ryan Reynolds has filed a motion for sanctions against Wayfarer. Now this motion is identical to the one Lively filed, which I covered in my last video, so I'm just going to leave you with this delightful image of Ryan Reynolds instead. Sorry about that. Then we had Melissa Nathan's sister, Sarah Nathan, filing a motion to quash Leslie Sloan's subpoena. Now, a lot of the arguments are the same as James Patuska's opposition to Sloan's motion to compel his interrogatory was. So this is a longer response than Patuska's and cites a lot more case law because it's a response to a different motion, but it largely contains the same arguments. So here I've picked out 2 pages which give a good summary. In yellow are the reasons listed for why they want the subpoena quashed. And Sarah Nathan cites reporter's privilege, the New York Shield law, that the subpoena is overly broad, unduly burdensome, and the information can be obtained elsewhere, and so on. In green are all the requests from the subpoena. So this is the information that Sloan is seeking from Sarah Nathan. And essentially, it's everything. All communications with everybody, about everybody, and everything. Sloan even wants Nathan's communications with, well, Sloan herself. I'm going to hold off saying too much because I want to see Sloan's response. Then we had Child USA filing an amicus brief in support of Blake Lively's motion to dismiss. Now, most of this is the same as the other amicus briefs that were filed to this point. There's the usual information about the authors being world-renowned pioneers, their statistics, and all the various ways that this is essential to survivors. So I picked a few points of interest. In blue, the organisation confirms that no one has paid for the commission of this amicus brief. Now that is very carefully worded, because what they left out was the fact that Sloan's law firm donated it was at least $10,000, so somewhere between $10,000 and $25,000 to Child USA, and that Hilary Nappy, the author of this brief and board member for Child USA, was formerly employed by Sloan's law firm. In orange is the emotionally charged pressure that any decision that doesn't go in Lively's favour will have devastating consequences for all survivors forever. In pink, Child USA confirms that there are no rules regarding amicus briefs at district court level, and the decisions regarding them are completely at the judge's discretion. Well, holy shit. If only someone had tried to explain this or correct the misinformation being put out about that. Wait, I did. I got bullied, harassed, threatened, false allegations made about me, xenophobic comments made about me, attempted doxing, and accused of being behind a cease and desist recently sent by Jones's lawyers. Yeah, that all happened. You can see my last video where I talk about that. Then Wayfarer filed a motion to compel Lively to provide medical information to support her claims of infliction of emotional distress. Wayfarer confirmed that Lively wants to withdraw her intentional emotional distress claims, as she does not want to provide details of her medical providers or have Wayfarer obtain 4 years of medical records to verify her claims. Now, Wayfarer agreed to the withdrawal of the claims in principle. However, the problem is that Lively wants to dismiss her claim on a without prejudice basis, which would allow her to refile at a later date and potentially in a different court. Wayfarer asserts that if she wants to withdraw her claims, then they are entitled to request that she close all avenues to potentially revisiting these claims by dismissing with prejudice. Failing that, if she wishes to make the claims at any point, she should do so now and defend them in this current lawsuit. Wayfarer laid out all the claims Lively made about her emotional well-being and mental health, which she alleged were the result of Wayfarer's actions. Of note, Lively also alleged that her husband had also suffered severe emotional distress from these actions. And she also said her children did. Now, I've never understood why they would have been so greatly affected by the claims Lively's made, but the medical records will not be obtained as they are not bringing their own claims for these damages, and Lively should not have made these statements. Wayfarer confirmed that they are seeking 3 things. 1. The names and addresses of medical and health providers who treated Lively's emotional distress. 2. All reports and treatment notes from those providers in relation to these claims. 3. An executed HIPAA form to release her medical and mental health providers' details so that Wayfarer can obtain her medical records for the purposes of this litigation. Lively refused to release this information, despite it being highly relevant to her claims. Wayfarer cited a series of cases which all support the position that if a medical or mental health issue is asserted as a claim, then doctor-patient privilege is waived. Wayfarer also cite case law that confirms that where a party inserts physical or emotional injuries as part of their claim, they are required to sign a HIPAA-compliant authorization form for release of their medical records. Wayfarer confirmed that a meet and confer took place via telephone on the 28th of May. During that meet and confer, Lively's counsel notified Wayfarer that due to Lively's objections to the disclosure of her medical records, Lively was electing to withdraw her claims that specifically referred to IED, but refused to do so on a with prejudice basis. Wayfarer state that Lively's counsel edited the proposed stipulation so that the claims would be dismissed without prejudice. The emails and red lines were attached to this, but I am not going to cover them here. Wayfarer are essentially asking the court to grant their motion to compel Lively to produce the details of the medical and mental health providers and the signed HIPAA-compliant authorization form for them to obtain the relevant medical records and assist them to defend themselves from her claims in this current lawsuit. There is a footnote where Wayfarer alleged that Lively improperly designated her intent to withdraw her claims as confidential. This designation requires the party to hold an urgent meet and confer to address the issues. Wayfarer alleged that Lively was using this to obstruct their legitimate right to seek relief from the court. The designation was subsequently withdrawn in subsequent communication, which was not marked as confidential, and it was attached to the motion. Now, this was likely to have been an oversight, but it is funny to see Wayfarer snarkily point it out. Lively did fire back with a blustering response, accusing Wayfarer of trying to generate the same media headlines with their filings as they did with the Friedman letter that was successfully struck from the docket. They requested the judge grant their dismissal of the IED on a without prejudice basis, strike Wayfarer's motion, and order sanctions on them. So the judge soon responded. He denied Wayfarer their motion to compel, but only because the parties had agreed to the claims being withdrawn. He told Lively to agree one way or another to the claims being withdrawn, but if they do not get withdrawn, she will be precluded from providing evidence of her emotional distress. And the judge ignored the request for the motion for the strike and the sanctions entirely. Next, 14 organisations came together to file a group amicus brief in support of Blake Lively's motion to dismiss. I'm going to skip over the statistics because they are similar to the other briefs, and for every study they bring to support their positions, there are likely to be at least one other study that supports a different stance. So, in pink, the organisation stated that they are offering to assist the court as active contributors and experts in the scholarship surrounding the dynamics of sexual violence. They also claim that they are uniquely qualified to assist the court to understand the interests of victims. Remember this because I will return to it later. In green, they state themselves that studies have been carried out where people, college level students, were asked to consider personal examples of where they were confronted with a serious allegation of any kind, and then asked to measure their own use of DARVO. Now, that was the wording that was actually used. I'm sorry, but if someone is recalling a time when they were personally accused of something, including allegations that have nothing to do with sexual harassment or sexual assault, and then they were asked about their response by being told that denial is DARVO, then I personally consider that gaslighting. People naturally deny allegations of all kinds that they believe are false, and so they should be able to do so without fear of it being given a manufactured and overused label that is widely associated with sexual and domestic violence perpetrators. In yellow, the organisation said that the legal process is re-traumatizing, expensive, time-consuming, and hostile. And I agree that it is certainly that. Most litigation is. You wouldn't be there if you didn't need to be. But I'm not sure whether anyone has informed the author that Blake Lively has her own lawsuit against Wayfarer. And in fact, she filed first. So seemed prepared to put herself through such a process. In blue, the argument is made that that victims of sexual harassment or abuse are often charged with false reporting of crimes. Now, whilst I appreciate that is a problem, they do appear to concede that being falsely accused or charged is a possibility that they're aware of. So I would be keen to ask, what about the men and women who are falsely accused of harassment and abuse? There are problems on both sides, but the organisations are being disingenuous by not acknowledging the fact and seeking solutions that protect everybody as best possible. In orange, they concede that Lively is likely not the intended target for the protections against financial expenses associated with litigation. However, they want the court to note, just in case Lyman misses in every Lively party's filing between New York and Texas, she is up against a billionaire who has promised to spend $100 million on her. They are stating an as yet unproven statement as a factual basis for this law to apply to her. I agree better resources are needed. But do you know who doesn't need those resources? Is Blake Lively. In purple, there appears to be a bigger tone shift, and now Wayfarer's claims are being referred to as meritless, before seeing any evidence and without backing up their view. This is not merely providing background context of victims and understanding of sexual harassment. This is now stating an opinion on the merits of Wayfarer's claims without seeing any evidence to support that view, and it feels like an overstep. This is one reason why amicus briefs are usually seen at the appellate stage. All the evidence has been seen and heard. Here, they are trying to prevent the evidence from even being obtained. Finally, in green, they complete their amicus brief, which is more like testimony at this point, by asking the judge to dismiss Wayfarer's quote-unquote meritless claims at the early dismissal stage, as the effect of not doing so in this high-profile litigation would leave a chilling effect on survivors. These amicus briefs are disappointing to see because there have been a series of connections between them and Lively's lawyers. There are even connections between some of the organisations or law firms drafting them and Sloane's company or lawyers. The concern is that these conflicts of interest are not being disclosed. And as I've said before, it now feels like Lively's lawyers have a difficult client and have gone through their address book to see which organisations have benefited from them being on a board, giving a donation, or carrying out pro bono work. I'm sure most people will know this, but when we use the term pro bono, we are talking about free legal work. Next, we had a decision from the judge regarding Jones Works' request for a protective order, which was prohibiting Wayfarer from enforcing their subpoena to Edgeworth, and that request was granted. Now, in my opinion, Judge Lyman actually made a good point that Wayfarer didn't try to argue that the crime fraud exception applied to each communication. So Wayfarer argued it kind of as a blanket, as opposed to applying it to each communication, which is what they're supposed to do. And they didn't really try to argue that Van Zan was a crime, particularly. I mean, we can all sit and say it's obvious, but Wayfarer is for Wayfarer to make that argument to the judge, and they didn't do that. I'm not worried about that at all. They have been absolutely swamped with things they've had to respond to, and what we see on the docket is about 1% of all the other work they're doing behind the scenes, which we do not see. All the phone calls, all the emails, all the collating of information to send out to the opposition, all going through the information they're getting in. There's a huge amount of work that's going on that's not hitting the docket. So I think they made the argument. I think they didn't really care whether they, you know, are able to enforce the subpoena or not in particular, because for me, this is not the end of the matter. Wayfarer will seek the information from alternative avenues, including from Stephanie Jones herself. So I'm not worried at all. Then we had James Vituska come into an agreement with Leslie Sloan. He signed a declaration as part of that agreement. Now, my personal opinion is he changes his story. I've said this before. I feel like he was feeding Melissa Nathan bullshit, or at least he's the kind of person who changed the story depending on who he's talking to. And there is text message evidence that he was secretly, having conversations with Leslie Sloan as well. So I'm not convinced. He claims he slipped up. I'm not convinced that he misspoke, because he would have been subsequently asked about these comments long before this, and he didn't correct him at that point, or at any point after Wayfarer's original complaint or their amended complaint. I don't believe he didn't expect to see the texts in filings either. He was in direct communication with Brian Friedman, and if he didn't want them disclosed, he doesn't appear to have made that clear. But also, they are Melissa Nathan's side of the communications, and he can't request that they are not produced or included in a legal document. First, to confirm, though, Sloan cannot use this to bolster her motion to dismiss, so before anyone thinks that she's off the hook, she really is not. Second, Wayfarer will be able to test this like any other piece of evidence, such as discovery or testimony. So this is not the end of the matter. I envisage that Wayfarer will probably have him in a deposition, and we'll be asking him, why did you tell us this? Why didn't you correct it at the earliest opportunity? How much has Leslie Sloan offered you? Have you been threatened? So this document, as far as Sloan is concerned, it serves a purpose. I don't think it helps her particularly. I think James Vituska was prepared to say whatever was needed to get out of being compelled by Leslie Sloan. Then we had a motion filed by Jed Wallace for a stay of discovery in the New York case. Now, it seems like Lively got nasty because Wallace dared to object to a request from her husband. In green here, Wallace confirms that Lively requested he consent to 40 depositions. The depositions allow a maximum of 7 hours each, so that would potentially force him to endure 280 hours of deposition testimony, which he would also have to travel from Texas to New York to sit for. In orange, Wallace makes his first argument that he is not domiciled in New York and street relations is not incorporated there either. Neither individual nor his business have contacts in New York, So he argues that New York does not have general jurisdiction over him or street relations. In the Texas case, Lively is arguing for California as jurisdiction herself, not New York. So there is nothing really tying him from either side to New York. In pink, his second argument is over venue. He argues that the plaintiff, here Lively, has the burden of proving that the venue is proper for each claim and each defendant. Wallace states that her argument that New York is the proper venue is not supported by case law. This has been a major argument between him and Lively in the Texas filings too. In yellow, Wallace confirms that Lively originally filed 3 claims against him. 1. Intentional infliction of emotional distress, which she is now withdrawing. 2. False light invasion of privacy, which is not recognized in either New York or Texas. And 3. Aiding and abetting harassment and retaliation in violation of California law, which Wallace states she has not sufficiently pleaded that he was aware of any harassment, even if her claims are true, or that the quote-unquote astroturfing she claims occurred, falsely according to Wallace, was known to be part of any retaliation for any sexual harassment complaint. And I have said this myself, what motivation would Jed Wallace have to retaliate against Blake Lively for complaints that had nothing to do with it? She made more than a year before he was brought on for his services. It makes no sense, and she has not connected any dots. In blue, we get some interesting information. Lively's requests were seemingly reasonable, actually, until Ryan Reynolds served a Rule 45 subpoena on Wallace in his capacity as a consolidated defendant in Wayfarer's complaint, which does not actually include Wallace or Street. Lively's complaint against Wayfarer, which does not include Wallace and Street, also does not include Ryan Reynolds. At a meeting confer with Reynolds' counsel, who are obviously the same as Lively's, Wallace communicated his belief that he suspected the use of competing discovery procedures by Lively and Reynolds, and pointed out that Lively's request suggested that him and Street were ancillary to them, as Lively had made no further requests. He made a request to stay further discovery to the Lively Reynolds counsel. Following day, Lively denied the request for stay and served 98 document requests and 16 interrogatories, which also include requests for, and I'm quoting here, any documents Wallace and Street have touched since the 1st of July 2024, which is just absolutely effing ridiculous. And is clearly, that's quite a malicious and spiteful thing. There's no real reason behind that. They're just being spiteful. So, and the footnote at the bottom just confirms that Ryan Reynolds, as if we all didn't know, is Lively's husband and the consolidated defendant in Wayfarer's complaint against Lively. So in green, which did start on the other page, Wallace confirms that a significant portion of the discovery Lively is now seeking will include confidential client details and documents. They rightly assert that this will interfere with their business because clients will perceive their information to be made public, and this information is not necessary. In orange, Wallace confirms that discovery has been broad for other defendants, but the discovery has very little to do with Wallace or Street. Even if Lively's allegations were true, he was only involved for 3 months, beginning in August 2024, which was long after the alleged harassment was said to have taken place. In yellow, Wallace states that there will be no prejudice if his discovery is stayed until closer to the end of the discovery period, or until his motion to dismiss is ruled upon. And in pink, Wallace advises the court that him and Lively attempted to meet and confer to discuss these issues, and Lively responded by opposing his request and serving well over 100 requests to Wallace and Street. Doesn't Blake Lively sound delightful? So then Leslie Sloan filed a request for an extension of time to respond. She wants her deadline for a response regarding Sarah and Nathan to be extended from the 10th of June to the 17th of June. She also wants Sarah Nathan's deadline to reply to her response extended from the 12th of June to the 24th, which obviously makes sense. If Sloane's gets delayed, then Sarah Nathan's should get an equivalent delay to reply back. This was obviously agreed, that both parties agreed to this, and subsequently was granted by Judge Lyman. The next filing that came turned out to be a real gift. It is the funniest document I have ever read. Well, at least the funniest one I've read in a really long time. And it's quite a nice birthday present for me. I'm just going to leave this one page up, which has the best comment for me anyway. But I'll summarize some of the main points. It was a really long, it was a long filing to go through, and I did a very long, detailed thread on it. But it was absolutely worth it. I laughed till I cried. It's incredibly snarky, but one thing I will say is Charles Babcock really cares about his client and cuts through the opposition's bullshit. So from the start, Wallace basically calls Lively's motion to dismiss introduction horseshit, but his lawyer does it in a professional and dignified manner. Wallace blasts Lively for basically bragging about herself, her career, her claims against Baldoni, who has a billionaire friend, the allegations against Wayfarer, her contractual rider with Wayfarer, whilst basically saying next to nothing about Wallace and Street. That is the page on the screen now, and that page alone was a fantastic read. So Wallace points out he was never on the set of It Ends With Us, never had any relationship with Lively, never harassed her, and never entered any contract with her. He was also not brought on until more than a year after she alleges the harassment took place. Wallace pisses off Lively's assertion that Street was recently incorporated as a California business as a mere fun fact, as its principal place of business has been in Texas for a number of years now. He also says that Lively skipped over entirely the period that Wallace was an independent contractor to TAG, that's Melissa Nathan's company, in her history of Street, and only mentions it again when she refers to the CRD quote-unquote draft complaint. Wallace also states that several of Lively's causes of action are outside the jurisdiction of either the CRD or the EEOC, such as breach of contract and negligence, amongst others. And he's right, contract claims are not Title VII claims. Wallace points out that Lively admits to mentioning in her motion to dismiss that she did not include Wallace or Street in her New York lawsuit initially, and that they were only added much later. He also points out that Lively initiated legal action against him in Texas by filing for a Rule 202 petition and engaging process servers. Wallace also claims that the allegations that he evaded service are false, but even if they were true, we demur, which is French for so what. Wallace alleges that the process servers' efforts to serve him were minimal at best. They simply honked their car horns outside his gated property. He says that Lively is back to chasing her tail because she knows that Street and Wallace did not engage in any sexual harassment on the set of the film, no matter where it was. And the same holds true for the alleged retaliation. Wallace confirms that because of Lively's falsehoods and fabricated claims, he has lost business and suffered emotional and physical harm. He states that Lively dismissed this assertion in a single sentence in her motion to dismiss. Wallace reaffirms that Lively has no evidence of any claims against her, as she confirmed under penalty of perjury in her Rule 202 petition. He claims that Lively has attacked his professional reputation by suggesting he weaponizes digital armies and paints him out to be, quoting here, some sort of evil, no bar too low, public relations thug. Wallace rebuts against Lively's assertion of the litigation privilege by saying that neither Texas, California, nor New York would support dismissal due to the fact that the draft complaint was sent to news outlets for publications. He alleges that even if she had litigation privilege, she effectively lost it by repeating the draft complaint allegations for publicity purposes. Wallace rebuts Lively's assertion of the fair reporting privilege by stating that she is not a newspaper or other periodical. He then gets into the Section 47.1 privilege by pointing out that it only applies to communications made by individuals without malice. He points out that it doesn't apply to all the claims, just the defamation. And that the privilege doesn't just apply to all out-of-court publications, only to factual information related to an incident, and Lively CRD goes beyond the sexual harassment. He states that Lively has not even explained how he is alleged to have weaponized a digital army, or that her IED claims and false light invasion of privacy are covered by California, but not privileged by Section 47.1. Wallace says that he did not want to be involved in all of this, but Lively brought him in, so she should be forced to see it through. It's a great set of arguments overall. I don't know why Lively is still flogging this dead horse. She would be better off just settling and letting go of Jed Wallace, in my opinion. I also want to make this point. She is alleging that similar claims, in that Jed Wallace aided and abetted this harassment and retaliation. She is asserting the Section 47.1 privilege here in this case. No organisation appear to be coordinating a series of amicus curiae briefs here, despite Lively asserting this Section 47.1 in a federal court. There is no concern here that she should be dismissed, that she may be compelled to endure an abusive discovery process, or that the judge ruling against her may set victims back years, and all the other fluff that was thrown into the New York court. I guess in Texas, there are no law firms or organizations that Lively or her agents were able to call in favors from. Wayfarer were then hit with another motion to compel. This time it was about communications between them and content creators. To clarify, this could include me, as I have emailed Brian Friedman on several occasions with fines and information, including the October metadata. So I will let people know if I receive anything that stems from this. I probably won't, but it's something that I'm preparing myself for. In yellow, Lively and Reynolds confirmed that they are seeking basic information regarding the potential witnesses and documents relevant to the litigation. Lively and Reynolds are seeking that are requesting that Wayfarer identify any email account from May the 1st, 2024 to present that was accessible to any third party, including the media and content creators, for the purpose of communicating information of any kind. And that is where I may get caught. Not caught, I haven't done anything, but that's where I may fit into this. Hilariously, Lively and Reynolds have the front to suggest that they believe Wayfarer has been engaging in covert tactics to communicate with third parties whilst avoiding leaving a paper trail or digital trace. Do these idiots seriously hear themselves? I mean, to be very clear, there was no secret email address that I used. What I used was the one that was publicly available. It's as simple as that. So it depends what Lively and Reynolds kind of really mean by this. So in orange, in a bizarre display of paranoia, which sounds like Reynolds could be behind this, Lively and Reynolds suggest that third parties have gained access to an email without using login credentials through means that are not known to Lively and Reynolds, except such types of means are clearly known to them because they are suggesting it. In blue, Lively and Reynolds want the identities of all news reporters Wayfarer have communicated with in any manner concerning Lively, Reynolds, their companies, the CRD, or the causes of action. Lively alleges that Wayfarer have previously, and still to this day, weaponized the media against her. And it will also say there is a line, I'll come back to it because I think it's on the next page. In pink, Lively says that Wayfarer should not be allowed to have discretion over the scope of their response, as Lively has alleged that they have participated in an untraceable smear campaign. In purple, Lively believes the retaliatory smear campaign is ongoing. What she also says in purple is that she is primarily suing Wayfarer for defamation for statements made after the 21st of December 2024, which is the day she filed her CRD complaint. Or it's the day after she filed her CRD complaint. Which is interesting. Because I thought the majority of the defamation occurred before she filed her CRD. Steve Sarowitz's claimed statement about Hamas and his $100 million he's spending on it, they all are alleged to have occurred before then. So I haven't really seen her throw many statements from December onwards into her complaint or amended complaint. But there we go. In yellow, Lively complains that Wayfarer's attempt to limit their response to individuals who are reasonably known or ascertainable makes no sense because they should know who they spoke to and when. In green, Lively and Reynolds request that Wayfarer are compelled to disclose the identity of all content creators from the 1st of May 2024. Lively and Reynolds define content creators as any individual or entity who seeds, generates, creates, or influences social media content or provides related digital or social media services directly or indirectly at the request of or on behalf of any Wayfarer party or their agents or affiliates. So that's very broad. In blue, Lively and Reynolds are complaining that Wayfarer are attempting to limit the definition to content creators to individuals with over 10,000 subscribers on any single platform and exclude niche individuals whose platforms are unrelated to the subject matter of this litigation. So I look forward to seeing Wayfarer's response. I'm not going to say too much about this, but I'm sure we'll get a response from Friedman pretty soon. So anyway, thank you for joining me again. I'm hoping to have a few lives this week. I'm in the process of negotiating a few really good guests to join me on a live stream. And I will be, as usual, going through the filings and putting up my posts and threads on X in real time. So please do check that out. Thank you very much for listening, and I will see you at the next one.